economic freedom fighters and the Speaker of the National Assembly and others, and Democratic Alliance and the Speaker of the National Assembly and others for hearing.
May it please the Chief Justice, members of the Court, my learned friends, Mr. Porter, Mr. Luca Toby, Mr. Mitchell, and I appear for the economic freedom fight.
Thank you, Mr. Trengove. Thank you, Mr. Katz.
Chief Justice and Justices of the Court, I'm here for the Speaker of the National Assembly.
Argument of Corruption Watch, which is devoted to this issue, and we, with respect, join in the submissions that they make. We submit that one of the most crucial features of this power is not only its language, but the shift of language from the interim constitution to the final constitution in the formulation of the public protector's powers. Under the interim constitution, she was given the power in section 112(1)(b), and I quote, to endeavour to resolve any dispute or rectify any act or omission, a very soft power of mediation and conciliation. That language was changed in the final constitution, quote, to take appropriate remedial action. And one has to take seriously that deliberate choice of language and the change of language, which can only mean, firstly, that she is given the power to take remedial action herself, not merely to recommend to other people to do so. And secondly, that the remedy she is entitled to employ must be an appropriate one. And this court has repeatedly held from Fosey on, in the Fosey line of cases, that appropriate relief means effective relief. We submit that the same goes for this power. You might think that that leaves her with unduly wide powers, but let me say that there are two very significant limitations on that power. The first is that the issue of an administrative order would constitute administrative action and therefore be subject to control under the Promotion of Administrative Justice Act, which is a significant control both in the manner of decision-making and on the reasonableness of the decision, of the outcome itself. Secondly, the Section 182(1) prefaces this power, as it does with all her powers, to say that it may be regulated by national legislation. Now, the current Act predates the final constitution on this score. It was not amended to take account of this change in the constitutional powers conferred on the public protector. But it would remain open to Parliament to regulate the public protectors, the exercise of this power, in a very significant way. We know of all the jurisprudence that says that the power to regulate is a very wide power and it stops short only of total prohibition. But it is open to Parliament significantly to regulate the exercise of this power. So an objection that the outcome, the remedy, the interpretation for which we contend is unduly wide is with respect unfounded, because there are these two very significant sets of control over. May I turn then in the third place to the conduct of the President, because we submit that the President defied the public protector's orders and that his defiance constituted a violation of his duties under the Constitution. May I first deal with the facts before I turn to the constitutional implications of those facts? The conduct of the President, or the President's response to the Public Protector's report, starts with his report of the 2nd of April 2014. It is in the EFF papers at page 259. And I won't go there because it's an early response, but I note that at page 260, the President says two things. He says, firstly, describes the public protector's orders as recommendations, and secondly, says, I must now apply my mind to her recommendations and the report of the ministerial task team. So he doesn't recognize that her orders enjoy any status beyond that of a recommendation, and he treats them as if they are no more and of no more significance than the recommendations of his own ministerial task team. That was the President's first report. Then there was his second report of the 14th of August 2014. That is at page 52 of the EFF's papers. And again, the same thing. He says, firstly, at page 65, in paragraph 51, speaks of the public protector's proposals. And secondly, at page 70, in paragraph 63.2, says that he has decided that the Minister of Police must now decide whether he should repay anything, and if so, how much. So he doesn't recognize the binding nature of the Public Protector's report at all.
Mr. Trengove, are you rounding up, because now it is that time?
Certainly, Chief Justice. There then follows correspondence between the Public Protector and the President. The Public Protector's letter is dated the 21st of August 2014. It should have been in the EFF papers, but it's for some reason not been included in them. It was referred to by the Speaker. But this letter may be found in the DA papers at page 524, where the Public Protector takes issue with the President because she insists that her report is binding on him and not a mere recommendation. The President responds to that letter on the 11th of September 2014, and his response is at page 293. And we emphasize again two features of that response. Firstly, in paragraph 8, he says that the Public Protector's report is not binding on him. Sorry, that's paragraph 3. Public Protector's report is not binding. And in paragraph 8, that the Minister of Police will decide whether he should repay anything, and if so, how much. Then after that comes the President's answer in the EFF application. In his main answer, at page 337, paragraph 48, he again takes the same position as he had done before. The Public Protector has the power to recommend, but may not make an order with any force of law. In other words, her orders do not have any force of law, they are mere recommendations. There was the President's main heads of argument in this case. At page 30, paragraphs 61 and 62, again, that same position. But then came a switch. The President filed a further set of heads in response to the heads of Corruption Watch. And it seems that Corruption Watch may have persuaded the President that he was wrong, because in these heads, he now accepts that the Public Protector does have the power to make binding orders. If I can just give you the references. And he does so in paragraphs 3, 7, and 8 of those heads of argument. But he persists only with one residual point. It's a point made in paragraphs 14 and 19.4. He says that whilst I accept that the Public Protector has the power to make binding orders, she didn't do so in this case. In other words, paragraph 11.1 of her report was a mere recommendation. And it's common cause that she has the power too to make recommendations. So on the legal issue, on the powers of the public protector, there is no difference left between the EFF and the President. The President now accepts that she may make binding orders. She may sometimes also make mere recommendations. The only remaining issue is whether in paragraph 11.1, those were mere recommendations or orders. Now, that is why I took you to paragraph 11.1 in the first place. The President is too. It's formulated in mandatory terms, and it cannot, with respect, be sensibly interpreted as a mere recommendation. It was an order made by the public protector, and on the law that is now common cause between us and the President, he was bound by it. We submit that his defiance of the public protector violated his duties under the Constitution.
Mr. Trengrove, sorry to interrupt. As I understood the papers, I may be wrong, is that the interpretation given by the President to the report was that the public protector did not make a final finding in relation to the non-security related aspects, and that because that was still open, he could take steps to investigate whether they are security related, and he was still in the process of doing so.
Indeed, Justice Furneman, and that's why I started with the rather incongruous exercise of going through those findings, because I submit with respect that she unambiguously finds that 8 measures were unlawful. The President, because they were not necessary for the President's security, that 5 of those 8 measures were measures from which the President improperly benefited the President, and therefore that their cost and should be determined because he is duty-bound to repay the state for their cost or a contribution of it. And you quite correctly articulate the President's position, but we submit with respect that it's an untenable position. Those paragraphs of the findings of the report are simply not open to the interpretation sought to be placed on them. But it is all that is left in that debate between the EFF and the President. He's now conceded that the public protector may make binding orders. And that, with respect, is a huge concession and a very important principle. That's really one of the main reasons why the EFF is here, is to establish once and for all that the public protector may make binding orders. She has explained to you how the effectiveness of her office has essentially collapsed since the President made the point in Parliament that her reports are mere recommendations. And that's why it's so important in this case, not only for the resolution of this dispute, but for the effectiveness of the office of the public protector, that an authoritative determination be made that she may make binding administrative orders. We submit that the President's defiance of the public protector violated his duties under the Constitution. Firstly, under Section 181, sub 3. That section requires of all organs of state to assist and protect the public protector, to ensure, amongst others, her dignity and effectiveness. Positive duties to assist and protect the public protector, to ensure her dignity and effectiveness. Now, we submit that there cannot be a more flagrant violation of that duty, positively to assist and protect, than to flagrantly defy and disobey. So there was a violation of that duty. We submit that there was also a violation of the President's ethical duties under Section 96, 2B and C of the Constitution. If I may just go to them. The section says the following. Speaks of the ethical duties of members of the Cabinet And then 2 says, members of the cabinet and deputy ministers may not be act in any way that is inconsistent with their office or expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests, or C, use their position or any information entrusted to them to enrich themselves or improperly benefit any other person. The Public Protector has already held that the President, in accepting the benefit of the development at his home, acted in breach of this constitutional duty. But we submit too that not only was there a violation in that conduct, the President also violated this ethical duty in his defiance of the Public Protector, because he defied the Public Protector as President of the country in order to protect his ill-gotten gains. The Public Protector ordered him to make restoration to the state. He defied her to protect the wealth he had obtained in a manner held by the Public Protector to be unlawful, and in that way he used his position to enrich himself or improperly benefit other person. So we submit that not only his conduct at the time, but his response to the report constituted a violation of Section 96. Let me say that there are these 2 constitutional violations, but they are special in this sense, that all of us are bound by the Constitution and all of us have to obey the Constitution. But we submit that there is a singular and heightened duty on the President to do so. And the Constitution specifically makes that clear by 2 of its provisions. The first is Section 83B, which specifically says that the President must uphold, defend, and respect the Constitution as the supreme law of the Republic. Uphold, defend, and respect the Constitution. He is our leader. It is his duty in the first place not only to obey, but to uphold, defend, and respect the Constitution. The second provision is Section 87, which prescribes his oath of office on taking office, and the oath itself appears in Schedule 2, where the President is required.
Sorry, Mr. Trengrove, a colleague was drawing something to my attention. I didn't hear the last section that you referred
Section
to.
87.
87.
Section 87, which requires the oath. The oath itself is in Schedule 2, Item 1, in terms of which the President is required to swear or proclaim that, and I quote, "I will obey, observe, uphold, and maintain the Constitution and all other law of the Republic." So that the President's constitutional violations in this case were not simply akin to any other violation by any other citizen. These were violations by the President, despite the very important, heightened, and singular duty that he bears under the Constitution.
Oh, if I may interrupt, Mr. Trengrove, at paragraph 13 on page 18 of the EFF's founding affidavit, there was reliance on 83.6. Are you no longer now relying on 83.6? I hear you only mentioning Section 83B.
Justice Kampepe, let me make sure. Yes, we confine our submission to 83B and C.
It's just that when you were making a submission, you didn't make any submission with regard to 83C.
No, we submit with respect that his duty arises both under 83B and 83C. I didn't mention it, I should have done so. Can I turn to the conduct of the National Assembly? The National Assembly, the facts appear from the Speaker's affidavit in the EFF application from page 156. But The aspects of it that I wish to emphasize is this. Firstly, from page 225, in paragraphs 141.2 and 141.3, the Speaker says the following. She said that in the National Assembly, the view of the majority party was 141.2. All the reports, that's in other words, not only the Public Protector's report, but also the report of the task team, all the reports should be considered and treated equally in order to avoid casting aspersions on any of the government agencies or structures that dealt with the security upgrades at the President's private residence. The Public Protector makes recommendations and may propose remedial actions, which remedial actions are not binding and enforceable on the organs of state. And it was that position, same position as that of the President, that informed the National Assembly's handling of the matter from then on, because you will see that they consistently acted in accordance with this perception. At page 234, you'll see that she deals in two very long paragraphs, 154 and 155, with the findings of an ad hoc committee appointed by the National Assembly. And what the ad hoc committee really did, and this discussion runs up to page 246, is to reconsider all of the findings of the Public Protector. In other words, the ad hoc committee arrogated to itself the freedom to sit in judgment on the Public Protector, and failed to recognize that the Public Protector's order was binding and that their business, properly so called, was to consider how to give effect to those findings and not merely to second-guess them, to go behind and sit in judgment on them. And there's then a long description of how the ad hoc committee overturned all of the findings of the Public Protector. And that culminates at page 246 in paragraph 156 in the adoption by the National Assembly of those recommendations of the ad hoc committee. In other words, this overruling of the Public Protector now was endorsed by the National Assembly. At page 247.
Mr. Trengrove, as you deal with it, was this a question of interpretation? In other words, was this based on lack of understanding of exactly what the remedial powers of the Public Protector entailed, or was it a deliberate defiance of a known interpretation of or meaning and extent of the powers of the Public Protector?
Chief Justice,
in other words, is there room for saying, I didn't know. Now that Mr. Trengrove has explained, now that the SCA has explained, I know. Or was it just an out-and-out defiance of the known position?
Let me say that one has one's suspicions about it. And the view of the law apparently depended on the party to which you belong. But I will argue the matter on the assumption that it was a bona fide error of law. In other words, that the members of the National Assembly, or those who supported this position, genuinely believed that the Public Protector's report was a mere recommendation, and it was up to them to determine whether to accept the recommendation or not. I will argue the case on that assumption. But what it still means is that they were desperately wrong in law, and as a result of that error of law, didn't do their constitutional duty. I will get to their constitutional duty shortly. So I accept, Chief Justice, it's an important issue. The facts aren't clear, but I'm prepared to argue the matter on the assumption that it was a good faith error of law. Upshot of the error.
Mr. Trengrove.
Justice Zondo.
This might take you a little back to the time when you were dealing with the binding nature of remedial action, but it may be connected with the role of the National Assembly. Now, two questions. One is, as I read the Constitution, it appears that the remedial action must be taken by the public protector. And if I am correct in that regard, I wonder whether if one looks at paragraph 11.1.1 of the report, where the President is ordered, so to speak, to take steps, whether that would fall within the ambit of take appropriate remedial action. Now, the one scenario which appears to me to commend itself as falling within, as probably falling within take appropriate remedial action, subject to what you may say and what other counsel may say, is where maybe the public protector were to institute action to recover public monies that have been wasted from somebody. It appears to me that that would be taking remedial action, and it would be, the remedial action would be taken by the public protector herself. But I would like your submissions on whether, where she orders somebody else to say take certain steps, that would fall within her taking remedial action. That's the one question. The second question is this. Section 13 of the Public Protector Act says the provisions of this act shall not affect any investigation under or the performance or exercise of any duty or power imposed or conferred by or under any law. It seems to me that what it says is, for example, that if, let us say, a minister is required to take certain action by the public protector, and in terms of some law, the minister is supposed to do some homework or some investigation before taking such action, the minister would be, doesn't affect the minister's obligation or duty to first undertake or perform that duty. Let us say, for example, the public protector were to say the minister must take disciplinary action against an official. The minister may be under an obligation in terms of the labor laws to give a hearing to that official first. And the minister would be required to approach the representations of that official with an open mind and without an attitude that says, I've been ordered by the public protector, so I will do what she says. So whether, when one has regard then to Section 13 of the Public Protector Act, whether it can be said that all the time when the public protector takes remedial action, it's binding in the sense that the person against whom it is taken has no choice. Thank you.
Justice Zondo, may I start with the second question because it's easier than the first? I submit that as far as the second question is concerned, yes, certainly, the public protector may not order anybody to do anything unlawful. And what's more, the public protector is obliged under PAJA to hear the defendant before she makes any order. So that would be the occasion for the minister to say, you can't make such and such an order against me because there are these requirements that I first have to fulfill before I can make such an order. And if the public protector nonetheless makes an order which requires the minister to act unlawfully, that would be a ground for review. So certainly I accept your proposition that the public protector can't order anybody to do anything that is unlawful. But there are remedies, firstly to avoid it, and secondly to cure it if she were to do so. If I may come back to the first question, and that is, what does it mean to say, take appropriate remedial steps? Submit with respect simply to sue is not to take appropriate remedial steps, because if there is a cause of action, that claim would have been there all along. The victim would have been entitled to sue anyway. The public protector would not add any value except perhaps the value that the Legal Aid Board adds. But to take appropriate remedial action is not the same as asking the court to take appropriate remedial action. It is to take it yourself. In other words, administratively to put right the injustice if one is found. And with respect, I can't make it more concrete than that, but perhaps just to refer you to what the SCA said in the Mail and Guardian case about the essence of the function of the public protector. That's the Public Protector v. Mail and Guardian, 2011, Volume 4, SA, page 420, at paragraph 6. The Office of the Public Protector is an important institution. It provides what will often be a last defense against bureaucratic oppression and against corruption and malfeasance in public office that are capable of insidiously destroying the nation. If that institution falters or finds itself undermined, the nation loses an indispensable constitutional guarantee. And we can just submit, as the SCA did in the SABC case, that role can only be fulfilled by an effective public protector. And a public protector who has no original power at all, but merely to help victims to sue with respect will not be effective. So we submit with respect that the power includes the power to make recommendations on occasion, but where appropriate, to make binding administrative orders. If I may just...
Mr. Tringove, if I could just follow up my colleague Zondo's question. Have you dealt with the possibility that Section 13 of the Public Protector Act permits ministers to carry on their lawful functions within the remit of their executive position, notwithstanding the Public Protector's remedial action?
Yes, no, I accept that is so. And I don't... It is a component we submit of our submission that the public protector is not allowed, doesn't have the power to order anybody to do anything unprocedural or unlawful. So that we would certainly not suggest that she becomes, that she's above the law and can make orders which in any way contradict the law.
Mr. Trentgrove, on a follow-up of the questions that my brothers have asked, if the powers of the public protectors, which are to take appropriate remedial action, are binding, I am contrasting that to Section 165 of the Constitution, which states that an order or decision issued by a court binds all persons to whom and organs of state to which it applies. Now, if the drafters of the Constitution wanted to make her orders binding, why was the language akin to Section 165 not used?
Justice Kampepe, we submit that there is a big difference between the administrative order of the public protector and the judicial determination of a court, in other words, the order of a court. The difference is this, that the administrative order, like all other administrative orders of ICASA or of whatever the regulator might be, administrative orders are just that. They are binding but subject to review by the courts. So that we would submit that the public protector's orders are administrative orders, binding on those to whom they apply, but subject to review by the courts. A judgment of a court, however, a judicial determination, is final and binding on all, and not subject to review by the courts. Of course, once the appeal mechanism is exhausted. But there is a fundamental difference between the two, in the sense that the public protector acts as the complaints office of the state, and she is given the power within the state hierarchy to put right injustice. And those orders of her putting right, i.e. remedying the injustice, are binding at an administrative level. They are binding administrative orders. But we won't suggest that they have the same status at all as judgments of a court. Can I just emphasize one feature of these powers? Firstly, if it's a mere power of recommendation or mere power to litigate on behalf of somebody else, we submit that it loses its effectiveness, and you would then pay lip service to the constitutional demand that she must be able to take appropriate remedial steps. In other words, effective remedial steps. The other is the point I've already made. Bear in mind, if you think that these powers are unduly wide, that it's open to Parliament to regulate them, and secondly, that they are in any event subject to PIA control.
Do you accept, sorry, this side, Mr. Chairman, do you accept that after the remedial action is ordered by the public protector, the National Assembly and the President would be entitled to say, well, we don't dispute these findings, but we want to investigate whether there are aspects of it that are unlawful, yes. and we want to investigate that and take steps.
Yes, indeed. And under this court's jurisprudence culminating in Curlin, if they conclude that the administrative decision is unlawful, the remedy is to review it and set it aside. You can't just defy it. You have to review it and set it aside. But as with any other, with a decision of the MEC to allow a hospital to be built, has the same status as that of the public protector who orders the President to repay the money. Both are binding, but subject to review. May I come back just to conclude on the conduct of the National Assembly. The National Assembly, I lastly wish to emphasize page 247, paragraphs 157 to 172, in which the National Assembly adopted the report of the Minister of Police in contradistinction to the Public Protector's report, to the effect that the President didn't need to give effect to the Public Protector's orders at all. Now, on this score, we submit that the National Assembly violated its constitutional obligations in the following respects. There is firstly its obligation to hold the President and his Cabinet to account, in this case, to hold the President to account. That's section 55(2), which provides the National Assembly must provide for mechanisms to ensure that all executive organs of state and the national sphere of government are accountable to it and maintain oversight of the exercise of national executive authority, including implementation of legislation, etc. And then there's 92(2), which is the other side of the coin, which says that members of Cabinet, which includes the President, are accountable collectively and individually to Parliament for the exercise of the powers and performance of their functions. Now, oh, and by the way, that accountability ultimately may culminate in section 89(1), which allows the National Assembly to remove the President from office. Now, in the event, what the Assembly did was not to call the President to account. I accept him for the moment that they were...
Can you just help me before you go any further? 89(1), how does it come in?
No, it's simply, it
Is it mentioned by the way, or does it feature?
No, no. All I'm saying is that there are 3 sections that deal with the National Assembly's powers to hold the President to account. Their duty under 55(2), the President's duty under 92(2), and ultimately the National Assembly's ultimate tool is to relieve the President. I'm not suggesting that they should have employed that power in this instance. But
I'm sorry, Mr. Trango. Can I just clarify one thing on that score? We have had submissions to the effect that the President has violated the Constitution. Now, I'm wondering, why do you shy away from what Section 89(1) says in relation to a serious violation of the Constitution by the President, and saying that in the context of the fact that it is only the National Assembly that can act on the basis of that ground against the President?
Justice Jafta, may I say, I didn't think that this case needed any stirring. And certainly the National Assembly has a particular duty to call the President to account in this case. Firstly, because it's the only institution that can call him to account. Nobody else can. Everybody else in the executive can be called to account by the President or his cabinet. But the President can only be called to account by the National Assembly. So it's a very important tool. And the National Assembly has the ultimate power of dismissal. It failed in its failure, it violated the Constitution in its failure to call him to account at all. And it's enough for us to demonstrate that it failed in that constitutional duty. It is unnecessary for us to go further to seek to persuade you that they should not only have called him to account, but should have relieved him from office. I'm not making that submission.
Now, what do we have to make of the submission that the President has violated the Constitution in this context?
Well, let me say, I have to ultimately persuade you that you have exclusive jurisdiction in this matter, or persuade you to allow the case to come here on direct access. For that purpose, it is important for me to demonstrate that both the President and the National Assembly failed to discharge constitutional obligations of the kind that renders this case subject to the court's exclusive jurisdiction. But as far as the merits of the case are concerned, the principles, apart from the resolution of this issue, which my learned friend will tell you is easy, the President will now pay back some of the money. But the principles at stake are the public protector may make binding orders. The President and the National Assembly acted in breach of the Constitution by defying those orders. Those are the principles which we submit are at the heart of this case.
Mr. Trengove, if we can make the finding that, or holding that the EFF is pushing for on this aspect, I would imagine that we should also be able to even make a mandamus as well.
Sorry, Micah?
A mandamus in instances where we say you ought to have acted in this manner, you have not done so, therefore we direct you to do so. You should immediately see then that separation of powers issues in here, in this scenario. Now I'm interested to know under what circumstances would it lie with us to make such a mandamus? Under what because one can well conceive of situations where something that warrants the National Assembly calling upon a member of the executive to account, but the National Assembly not doing anything about that. Does it lie with us in every such instance to direct, when we are called upon to do so, that the executive must, rather, the National Assembly must call upon the executive to account? Doesn't that raise separation of powers issues?
Justice Madlanga, it certainly raises separation of powers issues. It raises very sensitive separation of powers issues. It raises highly contentious political issues. And certainly if we didn't, the EFF didn't try to explore the full breadth of the remedies to which it might be entitled. And there is certainly an argument to be made for the proposition that the violation of by the National Assembly to perform their duty to hold the President to account justifies a remedy. The minimum remedy would be a declarator, but as you say, it might even be a mandamus. But the EFF did not push the outer boundaries of the remedies to which it might be entitled. You will have seen from its prayers 1, 2, 3, and 4, and the order that it proposed, that it would suffice if the court were to hold that the public protectors may make binding orders, that these orders were binding on the President, and that the President acted in violation of the Constitution by defying those orders. That they might be entitled to further relief against the National Assembly might be so, but they've not sought for it.
You see, the reason I'm raising the issue is that the EFF may well not have pushed the boundaries, but when you make an order as a court, you must also be forward-looking and see what its likely implications are going to be in future. So that is why I'm asking, are we able to get an idea of what sort of scenarios or in what sort of circumstances would we be entitled either to make a mandamus or even a declarator?
That would be so certainly if the court was persuaded that the National Assembly did not act in error but in defiance. If that were so, then it would certainly have justified specific mandatory relief against the National Assembly. We don't make that case. We hope and trust that once they are told that the President has to obey the public protector and that it has a duty to call him to account, that it will do its duty without being forced to do so by the judiciary.
Mr. Trentgrove, would I be correct in understanding your submissions to say that the National Assembly was lackadaisical in its approach to the Public Protector's report?
Yes. I submit that what the National Assembly should have done was to say to the President, Mr. President, we have a report from the Public Protector. You are bound to obey the report, to implement it. Explain to us why you haven't done so, or explain to us how you will do so. Instead, they adopted his approach. This is a mere recommendation, it's not binding, and they adopted overturned all of the findings of the Public Protector and adopted the Minister of Police's report instead. That's not holding to account, that's whitewashing. So and I accept, they may have been motivated by an error of law. But even if that were so, even if one accepts good faith, then what they did was not to hold to account, as they are obliged to do. They say, but we have mechanisms in place. Well, I know that the section speaks of mechanism, but the substantive duty imposed on National Assembly is to hold the executive to account, not merely to have a talk shop in which the executive can be protected in their defiance of the public protector. But there's a second duty.
No, before you go there, let me just make sure I understand. Was it open to the National Assembly, or was it not open to it? Upon receipt of the Public Protector's report and the report from the President, the reports from the President, to look deeper into the issues with a view to satisfying itself about the correctness of certain facts, and thereafter arrive at a position that is not necessarily designed to second guess the remedial action taken by the Public Protector?
Chief Justice, with respect, no. The National Assembly, properly advised, should have said to itself, we are bound by, or the President is bound by the Public Protector's findings and orders. And our job is to hold the President to account. So our function is to hold him to account, in other words, to call him to account for the implementation of the Public Protector's orders. That is what they should have done. And whether for good reason or bad, they failed to do so.
And was it open to the President then, before we get to the National Assembly, as part of the report to be submitted to the National Assembly, to look into the issue so that as part of his report, he can share some perspectives with the National Assembly, and the National Assembly would then have both his report and that of the Public Protector for the purpose of holding the President accountable?
Chief Justice, yes, but the legitimate question for debate was how to give effect to the Public Protector's report. That would have been a legitimate area for debate. It was not a legitimate area for debate to second guess, to sit in judgment on the Public Protector. Was she right? Are her factual findings correct? What do I think of her her orders? Should I implement them on? Those were illegitimate debates because the President was bound by the report. If the President challenged the report, then his remedy was to take it to court. Then
yes.
Curlin kicks in.
I was about to get to that point, that if it was open to the President to look into these issues, just to satisfy himself that which the Public Protector has found is well-grounded, and he arrives at a conclusion that now there's a problem here. As I understand your submission, the only avenue open to him would have been to approach a court of law.
Review and not defiance. That is the answer. That's Curlin. That's Curlin.
Tranquil. As a follow-up to the question by my brother Froneman in relation to the investigation by Parliament and the President, you'll recall that in his recommendation, the terms of reference to the Minister in paragraph 63.2, the President seems to sanction a further parallel process by the Minister. And he seemed to go even wider than the remedial action in paragraph 11.1.1 of the Public Protector. What do we make of that?
No, that's completely unlawful. He was not allowed to second guess or sit in judgment of the Public Protector, and he's not allowed to mandate the Minister of Police to sit in judgment of the Public Protector. Their job was, their constitutional duty was to obey the Public Protector or to take her to court. So that, Justice Nkandla, thanks for making that point, but it was yet a further egregious extension of the defiance that the Minister of Police was mandated to sit in judgment of the Public Protector.
So if there's a flaw that lies in that sanctioning by the President in relation to what the Minister ought to have done, doesn't anything that flows from that, those terms of reference fall away?
Oh, absolutely. That report was an unlawful piece of defiance of the Public Protector, and its findings have no standing in law at all. So there can be absolutely no status in law of that unlawful attempt to circumvent and defy the Public Protector.
I beg your pardon. So if that is correct, if you find that to be correct, it means the Public Protector's findings remain because they were not subject to review. It means the Minister of Police report has no significance whatsoever.
No, we can
and
just ignore it.
And then we have to consider the appropriate relief.
Indeed, indeed. And the Public Protector's orders, findings and orders, they are binding in law. They must be obeyed, not second-guessed, overturned, circumvented. And the attempt to circumvent them is just an unlawful attempt. We can ignore it.
For my own peace of mind, I know my sister wants to put a question to you, but I just want to make sure I understand this. It becomes defiance if the president knew for sure what the correct position was, the correct position as articulated by you and the SCA, what the correct position was in relation to the remedial powers of the public protector. But if he didn't know, it can't be defiance, isn't it? It's just an error.
Well, if defiance implies willful disobedience, then I suppose that's so. And again, we must allow for the possibility that the president might have thought that that was the law. The evolution of his thinking suggests otherwise. But again, our case is not founded on proof of bad faith. So I'm not asking you to make a finding of bad faith. Our case is one of a failure to obey the Constitution. And that would be so regardless of whether he acted in bad faith or in ignorance of the law.
What would you then make of his mandate to the Minister of Police if he genuinely believed that the public protector's remedial powers amounted to, or the remedial action rather taken by the public protector amounts to recommendations? Would you say it was defiance? Would you say it was something else?
It remains. Let me leave the word defiance then, if it implies willful disobedience. But it remains unlawful. He didn't do what the Constitution required him to do, whether in good faith or bad. But for our case, that is enough. He violated the Constitution.
Paragraph 11.1.4 of the remedial action says the President to report to the National Assembly on his comments and actions on this report.
Yes.
Which actions was he supposed to take? I suppose the comments would be on the report, whether or not there's anything that is...
I understood that a report on his implementation of the public protector's orders, in other words, on the quantification of the money that he has to pay back and on the repayment of that money. I submit with respect that that is what it means in context. The following things, he must do the following things and then report to the National Assembly. That would be report on his implementation of these measures, not report on something else.
And the instruction to the Minister of Police would be ultra vires.
Absolutely unlawful. Chief Justice, I know that you would want to know that
If I may just be permitted,
yes.
Mr. Trengrove.
That should be the last question you entertain.
To understand, thank you, CJ. Thank you, CJ. If I may just be permitted to understand your submission, you do not submit that the National Assembly used their processes to avoid the public protector's report. Your submission is that they used the processes in error and in good faith.
Well, I don't know good faith or bad, but I'm not arguing for a finding of bad faith. I accept that the cause of action upon which we rely does not depend on a finding of bad faith.
Yes.
But what the Constitution required of them in the first place, and I'm still just dealing with firstly, in the first place, is to call the President to account for his implementation of the Public Protector's report.
Yes.
And it didn't do that.
Yes.
That was in breach of its constitutional duty.
And if one has regard to the fact that they established an ad hoc committee from the 19th of August, and still by the end of July 2015, nothing had really been concrete. Nothing concrete.
And what did that committee do? What did that committee do? The committee sat in judgment on the public protector. Was she right or was she wrong? They decided that she was wrong. And that's why they subcontracted the job to the Minister of Police. All of that is unlawful. They didn't do what they had to do, and that is to call the President to account for the implementation of paragraph 11.1 of the Public Protector's report. That was what they had to do. Let me say I've made that case under section 55.2, let me say that the same violation occurred under Section 181(3), because the National Assembly was obliged not only to hold the President to account, but under 81(3), like all other organs of state, was obliged to assist and protect the public protector. Now, it did the opposite. It didn't assist and protect the public protector to ensure her dignity and effectiveness. It participated in the President's undermining of the public protector's report and his failure to implement it. So, and I've said that the National Assembly has a particular duty to call the President to account. Firstly, Justice Jafta, because they are the only institution that call the President to account. But secondly, it is also an institutional role envisaged by the Public Protector Act itself. Section 82B of the Act says that, I may just find it, (82B) says the Public Protector shall, at any time, submit a report to the National Assembly on the findings of a particular investigation if, and there are 7 circumstances. Number 2 reads, he or she deems it in the public interest, and 3 reads, it requires the urgent attention of or intervention by the National Assembly. So it is one of the avenues, one of the remedies given to the Public Protector to ask the National Assembly to intervene, to call the President to account, to ensure that he fulfills his obligation under the orders that she made. I have two, Chief Justice, my learned friend Mr. Katz has said that I may have 10 minutes of his hour if I have to.
You've had 7 minutes of that 10 minutes already.
May I then be very brief, because I have to address you on jurisdiction. I'm not sure whether any of our learned friends still persist in their objection to it. But I submit in the first place that this case falls within the court's exclusive jurisdiction, and on that score relies on the jurisprudence of this court in 3 cases: Doctors for Life, paragraphs 19 to 27, Von Arbo, paragraphs 33 to 37, and Women's Legal Center, paragraphs 11 to 17. And we submit that this matter, the constitutional violations of which the President and the National Assembly stand accused, do fall within the narrow band of violation of constitutional obligations that trigger this court's exclusive jurisdiction, because they raise important questions. Those questions are of intense political contention, and they are questions to which there is no obvious answer. You remember the court, for instance, said the kind of duty which requires the organ of state, Parliament in this case, to determine how to discharge the duty rather than where the answer is obvious. In this case, how does the National Assembly call the President to account? What does it have to do to call the President to account? It's one of those ambiguous duties which this court has said constitutes a constitutional obligation which, if it is alleged to have been violated, triggers the exclusive jurisdiction. And we submit that this court's ratio in Doctors for Life is on all fours with this case. Doctors for Life, paragraphs 24, 25, and 26. But let me deal with one further requirement elaborated upon in Women's Legal Center, paragraphs 16 to 20, and that's the so-called agent specificity question. The court suggested that the kind of constitutional violations that would trigger this court's exclusive jurisdiction are only those constitutional obligations which are imposed on Parliament or the President and alone. But the court didn't hold that to be so. It merely said it was a pointer and a suggestion. And in the context, one should see it in the context of that case, because in that case the violation was a violation by the state of Section 7.2. And the point made by the court is that that is not the kind of constitutional duty where the violation by the president is a violation as a member of a collective and not individually. We submit that in this case, firstly, the duty violated by the National Assembly complies with the agent specificity requirement. That's a duty imposed only on the National Assembly. And once that breach brings the case within the exclusive jurisdiction of this court, it brings the whole case within the jurisdiction of this court. Secondly, the President's duties violated in this case are duties not imposed on the President alone, but on the on the Cabinet. And we submit, for instance, an allegation that the President, in violation of Section 96, unlawfully enriched himself at the expense of the state, would be quintessentially the kind of question that belongs in the exclusive jurisdiction of this court. And we submit that the mere fact that that duty might not be peculiar to the President, but might extend to all the members of Cabinet, if the violation, in other words, if the alleged perpetrator is the President personally, as opposed to a collective, then that also qualifies for exclusive jurisdiction. We submit...
Mr. Trengov, if I may just interpose in relation to the agent-specific test in Women's Legal Resource Center. Section 83C, if you can help me there. What does that duty entail? I'm aware that the applicant relies on Albert in relation to the duty under Section 83C.
Yes.
Would you please just elaborate on that?
Well, we submit that what that section does is to say that while all of us are bound by the Constitution, there is a heightened and singular duty on the President to uphold the Constitution. And we would couple that with the oath of office to say, yes, it is true that we accuse the President of constitutional obligations, but they are singular violations because there is a singular duty on the President a singular and heightened duty on the President to uphold the Constitution.
I don't understand. I mean, how does national unity come into the picture in relation to what happened here?
No.
Which aspect of 83C finds expression here?
Well,
I must confess I've battled quite a bit with the application of this section.
The emphasis should be on B, must uphold, defend, and respect the Constitution as the supreme law. And in C, we submit that it's only the last part, conduct which will advance the Republic. In other words, in the public interest. But we don't suggest that that in this case the national unity is of any...
Conduct that will?
No, we don't suggest that the first part...
No, the second part you say, how does it find application?
Well, it must be read together with B. B says uphold, defend, and respect the Constitution as the supreme law of the Republic. And C says that he must also promote that which will advance the Republic. That means he must act in the public interest, we submit. But we're not suggesting that if we don't make a case under B that we will be saved by...
I understand B.
Yeah.
I understand B. I don't understand C.
C is a footnote to B as far as our case is concerned. Chief Justice...
But Mr. Trengrove, I have difficulty myself with regard to your reliance on 83 to indicate that the EFF has established exclusive jurisdiction. If one has regard to what you yourself has relied upon, being our decision in Women's Legal Trust.
Yes.
I'm not sure if you are now submitting that you may not necessarily be relying much on 83C, but you may definitely be placing reliance on 83B.
Justice Kampepe, let me say in the first place, our main argument on exclusive jurisdiction is that the National Assembly breached its duty under Section 55, and that that meets the agent-specific test.
Yes.
As far as the President is concerned, we must confess that the duties violated by the President are not duties imposed on him alone. They are duties that he shares with the Cabinet and some other duties that he shares with all organs of state, for instance, under Section 181. But we say this, that the President's duty to uphold the Constitution is not just the same duty imposed on every other citizen to uphold the Constitution. And that is where Section 83 B and C comes in, and that is where the oath of office comes in. What is singular and unique about the President is that the Constitution imposes on him a singular and heightened duty to uphold the Constitution. But we can't take it further than that. We submit, our first case is that the National Assembly's duty is a unique duty, and if it qualifies us for exclusive jurisdiction, then the whole case qualifies for exclusive jurisdiction. The alternative argument is one for...
Pardon, Mr. Beg your pardon, let me just interpose. If we are minded to accept your argument in relation to 83 B and C, even though B was not pleaded, and we read that in conjunction with 167(6) of the Constitution, which is mentioned only in the notice of motion, but appears nowhere in the pleadings. What should you do there? Because the problem is that the applicant relies on 167(6) in the notice of motion, but does not take the point further in the pleadings.
No, with respect, we do submit in the alternative. We ask for direct access under 167(6). And let me say this about direct access. This Court's approach to direct access, we submit, is best set out in two cases. There's firstly Bruce and Vliesetex, which has been repeatedly affirmed, and that's 1998, Volume 2, SA 1143, paragraphs 8 and 9. But then secondly, also Mazibuku v. Sisulu, 2013, Volume 6, SA 249 CC, and that is paragraphs 34 to 35, and in the minority judgment, but which accurately surveys the law on this issue, in paragraphs 127 to 129. And what they say is this, is that only in exceptional cases will the court allow direct access. Now let me just say this about it. This is a matter of high constitutional and public importance. It's a matter of high political contention. Parliament is in disarray from time to time, and there is great disturbance and unhappiness about the failure to resolve this issue. Despite the SCA judgment, it is clear that this matter has not been finally put to bed. In contradistinction to other cases that have come here, the heart of this case, i.e. the status of the Public Protector's findings, has been before the High Court and before the SCA. So it is not as if the issue has not yet been ventilated in the lower courts. And the parties in this case agree that speedy resolution of this matter is important, and we refer in that regard to two statements on this score. Firstly, the State Attorney's letter, the one that was distributed a few days ago, a letter of 2 February 2016, paragraph 3, says, and I quote, "The need for finality is apparent." And then there's also the Public Protector's answer, page 387, paragraphs 17.1 and 17.2, where she makes it quite clear how the effectiveness of her office has been destroyed by this perception that her orders are mere recommendations. And on that score, in the final instance, let me also say this. The test for exclusive jurisdiction is a very obscure and complicated test, not easy to apply, and obscure at the edges. There is no bright line that tells one whether you're in or out. We submit with respect that in a case where there is an arguable case for exclusive jurisdiction, if the court should find that the litigant missed the exclusive jurisdiction requirement, but in a case in which that was arguable, it should be generous in granting direct access, because it would create an unjust system if the litigant was faced with a hard choice of choosing a court under a definition of which the edges are vague. Because if you go to the High Court, you might be non-suited there and told you should have been in the Constitutional Court. And if you come here, you might conversely be told you should have been in the High Court. That injustice of applying a vague test to the prejudice of litigants who find out at the end of the day they're in the wrong court could be ameliorated if this court, in arguable cases, is a little more generous in granting direct access, even where it should find that the case for exclusive jurisdiction was arguable but not satisfied. We ask, Chief Justice, we would ask for an order in terms of our prayers 1 to 4, but in the light of the recent evolution of the President's position on the issue, we submit that those prayers can best be given effect to in the manner suggested in the draft order that we circulated a few days ago. So we formally still ask for an order in terms of our prayers 1 to 4, but we couple that with a suggestion that in the light of the evolution of this case, the best way of doing it is in accordance with the order that we proposed.
Thank you, Mr. Trengrove. And for the benefit of those who are to follow, our undertaking to sit until 7 p.m. stands. It's not a threat. It's the desire to get this matter over and done with. So the ball is in your court just as it is in ours. Mr. Katz.
Chief Justice, thank you. Chief Justice, I had indicated that I would welcome intervention from the justices at the outset. And perhaps, in light of that offer from myself, what I intend to do in the beginning is deal with some of the questions that have been posed by members of the court to my learned friend, Mr. Trengrove. And then I will
maybe before you do, is there any ground that has not been covered that you would want to traverse?
Yes, there are certain facts.
You could just highlight that so that we know what is it that you consider
I will do so, Chief Justice. Thank you.
Necessary to still deal with.
The broad outline of my address will be I deal with the legal position regarding the Public Protector's powers.
Come again, Mr. Katz. I didn't hear that.
I'll deal with the legal position regarding the Public Protector's powers. That'll be the first topic.
We're not leaving that for Mr. Marcus.
I'll explain why I'd like to spend a few minutes on it. Perhaps, Chief Justice, seeing that you asked me that directly, let me deal with that up front. And I deal with that in response to Justice Kempepe's question to Mr. Trengrove about the question as to why the word binding appears in Section 165 but not in the relevant Section 182 of the Constitution. And the answer is this, from the DA's perspective. And it's contained in paragraph 44 of our heads, the remedial action has legal effect and must be complied with unless and until it is set aside on review. The SCA, and I'll take the court to it, does not ever use the word binding, but on the contrary, it accepts the DA's argument in this court, in the High Court in the SABC matter, and in that court on that very issue. And that the court will see in paragraph 45 of the SCA's judgment, where it deals with the various considerations that the High Court in that matter considered. And then 6 lines down in paragraph 45, it said, but a court is an inaccurate comparator, and the phrase binding and enforceable is terminologically inapt, and in this context conduces to confusion. For it is well settled in our law that until a decision is set aside by a court in proceedings for judicial review, it exists in fact, and there's legal consequences that cannot simply be overlooked, and there's reference to Odekral.
So it's a Curlin principle.
The Curlin principle. So we would submit that as we submitted the DA, as it's submitted in the SABC case, and as we've submitted in our heads of argument, the word binding is not one that needs to creep in to the debate on the legal effect of the public protector's powers. The real issue is her remedial action enforceable until one less set aside on review? And we argue, yes, it has legal effect, and that party or those parties, an organ of state subject to that remedial action, has a duty to comply with the remedial action unless and until it's set aside on review. So that's the first proposition that I'd like to deal with as far as Justice Kampepe's question to Mr. Trengrove. And the court will not see the word binding in the SCA judgment. I just want to touch upon the various other aspects of the SCA's judgment on the powers, because we and I include myself, have travelled a long road from that first day before Justice Skipper's 2 years ago, or 18 months ago. In paragraph 47 of the SCA's judgment, there is a statement which we submit will encourage this court to adopt a stance that Mr. Trengrove did not push for, and that is that on the facts of this case, there was defiance.
I missed out the last word?
There was defiance by the state respondents. That's the President, the National Assembly, and the Minister of Police. And I want to just touch upon this because it's not unimportant as we develop our argument. In paragraph 47, the SCA says here, that's in the SABC case, there is no suggestion that the public protector exceeded her powers or that she acted corruptly. Now, in this case, we have not found any suggestion by the government respondents that the public protector has exceeded her powers or that she acted corruptly. And to that, may I turn to paragraph or page 349 of the Public Protector's report. It's in the DA papers on page 223, where there is a suggestion from the President that she acted at a point procedurally unfairly. And it's not unimportant, the process that the Public Protector adopted in investigating the Nkandla saga. And it's set out in detail in her report. One of the features, which I will come to, which is a case is made out on these papers by the DA, that there was obstructionism, or there was obstruction and defiance of the worst kind, not at the moment her remedial action was taken, but from the beginning, when she started investigating. And that will, we would submit, influence the court as to how it deals with this question of defiance. But the point I wish to highlight is this. On page 349 of her report, she says, in summary, in respect of the President's response to her provisional report, the President said, it is tainted by a lack of proper procedure. She, this is what the President says, has not applied the rules of natural justice, It suffers from a lack of integrity and that this has been compromised by persistent leaks and public pronouncements, and it would seem that she has adopted the incorrect legal framework in assessing the implementation of the security upgrades. She deals with it as an answer in the next paragraph. She says, as I've already indicated, all the affected and interested parties were afforded a full opportunity to engage me on the evidence and information obtained during the investigation that appeared to implicate them. I've considered every comment and submission, including that of the President, for the purpose of this final report, and made changes and corrections where applicable to my provisional views, conclusions, and findings. I have also alluded in detail to compliance with the relevant legislation and legal processes after having considered the submissions made in this regard by the different parties, including the President. The point is this: when she took her remedial action, if the President was of the view, as he seems to have been, that there seemed to be a lack of proper procedure or that the rules of natural justice were not complied with, what is any person in this country who is faced with what they perceive to be that process, that illegal process, what are their rights? Judicial review. And that's irrelevant as to whether the remedial action is binding, is enforceable, is current, is anything else. That would have been what we would have called the appropriate bona fide response, if that was genuinely the views of the President.
Mr. Kat, sorry to interrupt. What difference does it make to your case and the relief you seek whether it was done in good or bad faith?
Justice Froneman, I had intended to turn to that as my last topic when I deal with the appropriate order. But what we would suggest... But
I understood you to give us permission to interrupt right from the start.
I welcome. The answer is this. If one has regard to the actual relief that we seek, which is contained in Volume 1, it's paragraphs 1.1, 1.2, 2, 3, and 4. We would submit, like Mr. Trengrove, that it's not necessary for this court to come to a conclusion that there was willful disobedience and defiance in order to grant the DA the praise that it seeks. However, the DA is of the view that given the nature of this matter, the interest of justice, the kinds of issues which relate to direct access, because this court has a discretion when it comes to direct access, and we'll refer to cases on that issue. The kinds of issues that the court's going to be considering under its just and equitable jurisdiction, that is 1.2 of our relief, and the Justice Malanga question, which is, could there be, and in what circumstances there be a mandamus against Parliament, and including Justice Jafta's question as to the role that Section 89(1)(c) plays, the question of defiance becomes relevant. But I would wish to turn to that as part of the basket. But may I go back to the SCA's judgment?
Mr. Katz, maybe you should give us the points that you want to address, because your time is not as almost unlimited as Mr. Trengrove's.
Yes. I do need to, on this question of the public protector's powers, I've indicated paragraph 47 and this question of the parallel process. We just want to make it clear that our view as in paragraph 47 on this question of the parallel process is concerned is that a subject to remedial action may, in appropriate circumstances, request another functionary to assist the target in respect of implementation of the remedial action. But what is not permissible, to the extent this isn't made clear in the SCA judgment, is what the target may not do is embark on a parallel investigation, and the words are in paragraph 52, in order to second guess the language used, the public protector's remedial action, and in order to perhaps at the end allow and I'll use the words of the SCA, adopt the position that the outcome of that parallel process trumps the findings, decision, or remedial action taken by the public protector. So we would hold the SCA judgment to our bosom, and we would say that this court ought to uphold the kinds of language and the paragraphs 43 to 53 of the SCA judgment.
Sorry to interrupt you, Mr. Katz. I'm interested in your answer to my colleague Justice Froneman's question. Is your answer that it makes no difference to the relief that the DA seeks, whether we find bad faith or whether we just find a violation?
Justice Cameron, if I may turn back to the prayers that we seek and touch upon that. For purposes of prayer 1.1, it makes no difference whether you find that the President made an error of law or otherwise. For purposes of prayer 1.2 and the type of order that the court might craft along the lines of 1.2, what is just and equitable, what is appropriate, that's where that issue will arise. And were the court to come to the conclusion, as we would urge, that there was defiance, then 1.2 perhaps was a little humble for the DA to ask. And the DA would well have been advised to ask for more. So that's the answer, Justice Cameron. But the court will decide as far as 1.2 is concerned. Similarly, as far as 2 and 3 are concerned, 2 and 3 are not dependent upon defiance. But if the court does define defiance, again, there would be an order along the lines of 1.2 added to 2 and 3, bearing in mind Justice Malanga's question and the debate that he had with Mr. Trengo. I would like to turn to the facts. And I'd made the point that on the facts this court may appropriately come to a conclusion of defiance. And I'd made the point that it wasn't simply after the remedial action was taken that the difficulties arose. And for this proposition, I wish to turn to page 102 of the Public Protector's report. That's page 99 of the DA the DA papers. This is foreshadowed in Mr. Self's affidavit on page 13 in paragraph 23. Perhaps I should read from Mr. Self, paragraph 23, and then turn to page 102 of the Public Protector's report. What Mr. Self tells the court is that during the course of her investigation, the Public Protector encountered considerable resistance from other organs of state, including and particularly from the President, for instance, and then there are various examples set out in paragraphs 23 and following. And perhaps I should just immediately turn to page 102. In paragraph 3.4.13, there is a discussion by the Public Protector of certain of the events that occurred during her investigation. And maybe it's worth me just reading 3.4.11 on a little bit up the page, 2 paragraphs up. The Chief State Law Advisor suggested that I should stop my investigation until the recommendations of the Internal Task Team had been implemented and the investigations of the Auditor General and the Special Investigation Unit had been concluded. At the time of the conclusion of my investigation, no investigation had been conducted, etc. Then in paragraph 3.4.13, at a further meeting that took place on 31 May 2013, arguments were again advanced that it was improper of me to continue to investigate against the wishes of the ministers who were satisfied with the findings of the task team and decided the recommendation of the task team that the next phase should be investigation by the Auditor General and SIU. The Chief State Law Advisor, Mr. Enver Daniels, supported the ministers at the meeting in question, arguing at some point that, and we would highlight this, constitutionally speaking, it was improper for me to investigate when the ministers had clearly decided as members of the executive how they wanted the matter investigated.
Mr. Kurz, who do you want to impute that to? To the President, to the National Assembly, or only to the ministers?
Justice Madlanga, we would submit, as we develop our argument, that this case goes far deeper than the question of the public protector's powers under remedial action. It goes to a systemic failure of government in general, and government including the other two branches, which includes the executive and the National Assembly as a whole, to hold to account that which is ultimately excessive, a homestead for one family with 250 million rand. And the question is, who does the DA wish to hold this question of blockage of the public protector's investigation to? And we hold it to all respondents, other than the public protector, all government respondents. Whether it's the chief state law advisor, whether it's the ministers, ultimately the buck stops with the president. And the president takes responsibility for the conduct of state officials who block or attempt to block a constitutionally mandated body, a Chapter 9 institution, in this manner. So to answer Justice Madlanga, the answer is all government respondents in this case are liable and responsible for this kind of blockage.
Even the Speaker, the National Assembly?
Yes.
But what connection is there between the National Assembly, the Speaker, and the Chief Law Advisor? What authority does Parliament have over him? I thought he was part of the executive in a sense.
He's probably an official in the Department of Justice.
What authority does the Speaker have over that, or any part of Parliament?
The National Assembly have a duty, as Mr. Trengrove pointed out, to consider the report of the Public Protector, which includes that paragraph, and deal with it in a constitutionally proper manner. And they didn't.
That I understand, and I'm sorry to interrupt you, Mr. Kurz, but I thought we were at a stage when an investigation was being conducted, and some officials, like the Chief State Law Advisor, were interfering or seeking to block the Public Protector in her attempt to do her work. I don't see how the National Assembly comes in. I have some understanding when you say the executive is in a way involved. I don't know how the Public Protector comes in. I don't even know how the Minister of Police has anything to do with with an official or a functionary in the Department or Ministry of Justice.
Chief Justice, the ministers there were certain ministers at the meeting. It was against the wishes of the ministers that the Public Protector continued her investigation. She makes that clear. I understand, Chief Justice, your question. But in order to answer the question, one must look at, we would submit, that the court should have regard to the context in which the National Assembly considered this report. It's not just a question of the National Assembly looking at paragraph 11 to read together with the President's response to paragraph 11, and as Mr. Trengrove would argue, paragraph 10. It's a question of the National Assembly considering this report as the Public Protector required as a whole. And when the National Assembly considers that there was this obstruction, it's something that the National Assembly, we would submit, had a duty under the sections that Mr. Trengrove mentioned, 181.3 and 55.2, to provide a mechanism that this kind of conduct should not occur in the future, whether it be from an official in the Department of Justice, ministers, or the President. That's the National Assembly's duty. And the fact that they didn't, but they rubber-stamped a whitewashing, if I may call it that, of the excess, we would submit, paints a picture which demonstrates what we would call a big picture of violence. I want to turn to another aspect of her report. And one knows that statistics sometimes, not always, but sometimes lie. But we would turn to page 405 of our report. It's page 251 of the DA papers. In paragraph 9.2.14 on page 250, the Public Protector says the extent of the difference between the expenditure incurred by the state in respect of the security measures installed at the private residences of former Presidents Botha, de Klerk, Nkandla and Mbeki, and incurred at President Zuma's private residence is an indication that the enabling policy framework anticipated something more modest. This is so even if we take into account the location and remoteness of the area of Nkandla. And on the next page there's a table. And we would ask the court consider the table because it's illustrative of an issue that we're going to turn to as a general principle when it comes to something that the former United Nations High Commissioner for Human Rights stated. There's a graph, and the graph demonstrates, I'm just called a graph, but it's just called a pie, what is it called, a pie chart, demonstrates vividly, it's on page 405 of the Public Protector's report. And we come back to this theme, whatever the powers or otherwise, or legal effect of the Public Protector's powers are, or were, or whether there was made an error of law by whomsoever, it seems to us that when one sees this graph and one looks at it, and one sees how the Minister of Police, how the National Assembly dealt with the difficulty that the Public Protector was investigating, and they came to the conclusion that there was no problem and that the President did not have to pay back a cent. One has to come to the conclusion that constitutionally there is something rotten. One cannot but come to that conclusion, that from a separation of powers point of view, to not hold the President to account by the National Assembly and for the Minister of Police to produce a report which has regard to a graph like this, we would submit requires constitutional invention by the courts. And I want to turn to
Mr. Katz. I'm sorry, Mr. Katz. I'm here.
Sorry, Justice Jeff.
Can I take you back to the threshold issue of direct access? Would I be correct to say that the DA only advances the convenience argument, which depends entirely on whether the EFF is granted direct access? If we refuse EFF direct access, the DA should be refused as well. Is that correct?
That's the way we have pleaded it in our notice of motion, which was drafted before the 8th of October 2015 when the SCA gave judgment. That's a game changer on the question of direct access. Because were the DA, well, let's assume the EFF to be refused direct access exclusive jurisdiction, and the DA were to be forced to continue back in the High Court, the inevitable consequence would be the High Court would have to rule in the DA's favour, bearing in mind the precedent of the SCA. The matter would then have to track through to the SCA, and then come back to this court, this matter. So the direct access issue has changed on the 8th of October 2015. That's number one. Number two, and I wish to refer to this court's jurisprudence in a case called Independent Newspapers versus Minister of Intelligence, 2008, Volume 5, SA 31, Constitutional Court, paragraphs 19 and 20 in particular, where this court stated, and perhaps, I believe Mr. Marcus was in the case, but if I remember correctly, and if I read the judgment properly, there was no application for direct access. But the court nevertheless granted direct access in terms of its discretion to do so for the reasons that are articulated in paragraphs 19 and 20. And what the court said was, in the present matter, the applicant, this is the newspapers, who applied for intervention, not direct access, intervention, does not have a direct and substantial interest in the subject matter of the underlying litigation. Its real and substantial interest rests elsewhere. It is to gain access to a relatively small but restricted part of the underlying record for public dissemination on the ground and the right to open justice. Strictly speaking, this claim it could assert without intervening in the underlying matter. And then the important point, Justice Jafta. It could have brought a self-standing application before the High Court, or in an appropriate case, an application for direct access before this court for the same relief it now seeks. And it seems to us that it didn't apply for direct access. It applied for intervention. It follows from what I've said that the application for intervention cannot succeed. That, however, is not the end of the matter. And this is the proposition that we advance. When it is in the interests of justice, it will be the test that this court considers. This court may permit a party to bring an application directly to it. There's no issue with that. For the reasons that follow, I'm convinced that it is in the interest of justice to dispose of this application as one of direct access. So even though it was an application for leave to intervene, which was rejected, the court said, well, for the next reasons, we grant direct access. Independent newspapers and the minister have acted under the mistaken belief they were entitled to intervene. That doesn't apply here. Even so, both want the dispute between them to finally decided to finality by us. That's not an issue in this case. The same issue applies. The President's made it clear he wishes finality, and I'll turn to his letter of last week for that proposition. All the EFF wanted finality, the DA want finality, the Public Protector wants finality, and one turns to paragraph 25 of her affidavit in the DA matter, and one sees the difficulties that are faced were this court not to hear this case at this point. And what goes on, this court goes on in the independent newspapers to say, both raise important constitutional questions which in all probability would have eventually ended up in this court, same in this case. Also, much proverbial water has run under the bridge, like in our case. The intervening party has spent much effort and money to place the issues before this court in no less than 3 oral hearings, and in certain instances they were spurred on by directions of this court. In any event, this court is already seized with a record of proceedings in issue. Whilst it would have been preferable to have the benefit of a judgment of another court, sending the parties to another forum at this hour may well work an injustice. Another important consideration is none of the parties is opposed to us adjudicating the matter, and I cannot detect any prejudice or unfairness against any of the parties concerned if we were to do so. In my judgment, dictates of justice urge us on the path of finality. I will accordingly dispose of this matter as an application for direct access. And we would submit, Justice Jafta, that's the complete answer to any of the difficult questions of jurisdiction. We hear.
Well, Mr. Katz, you've confused me. Is it still a conditional application or not?
We would support the EFF's application alternative, the application alternative for direct access. We could well understand that were that application to be rejected, it would seem odd to us that you could grant the DA direct access and not grant the EFF direct access. But in bolstering the EFF's, let's call it alternative application for direct access, we would submit that it's not in the interest of justice that the EFF's application not be granted, and the DA certainly should follow suit. So Justice Jafta and Justice Frenneman, that's how we would articulate the answer to these questions.
But I thought the authority you referred us to spoke to a situation where there was a matter already before the court. Now, if we reject the EFF's application, the main and alternative, there will be nothing left. How can the DA say, you still have to give me indirectly direct access to come in, even though there's no matter left for the court to consider?
No, Justice Jafta, the independent newspapers was a self-standing case for access to documents in another case. There's a line between the two cases. I appreciate that were the EFF to be out of court on a jurisdictional issue, whether it be exclusive jurisdiction or direct access, it would seem odd to us that the DA then should be granted direct access. I fully appreciate that. Was my answer to Justice Frenneman. But I have to answer the question but I have to, in answering the question, refer again to the interests of justice, and we would find it surprising were both applications, the EFF and the DA applications, not to be considered by this court from an interest of justice point of view, bearing in mind the water that's passed under the bridge, and in particular the 8th of October 2015 judgment of the SE and the President's most recent pronouncements on what he seeks. So we would submit that however the court frames it, and along the lines of the Mazibuko Eno versus Sisulu Eno case, this court must deal with the merits at this particular point. But we would submit that the direct access route is the preferable one for the reasons that Mr. Trengrove argued, where he spoke about this, the grey of the exclusive jurisdiction zones. And
Mr. Cass, a small administrative matter. You've been at it now for 40 minutes. You've surrendered 30 to Mr. Trengrove. You have 10 minutes in which to make your final submissions. Will you do that, please?
Yes. Before, I would ask that the court have regard to two facts which are in the papers, and that's the letter of 21 August 2014 from the Public Protector and the President's response, which is on page 531 of the DA papers, in which we find errors of law contained in the President's letter to the Public Protector, where he says the role of the Public Protector is akin to that of an ombudsman, and this is quite apart from the SCA judgment in the SABC case. And importantly, we would emphasize that he says in paragraph 6, whilst the Public Protector reports play an important role, they are for a variety of reasons, and the word is used, impregnable from review. So the President tells the Public Protector on the 11th of September 2014 that the Public Protector's report is not reviewable, despite on the 1st of June 2011, in the Mail and Guardian case, the Supreme Court of Appeal finding that Public Protector reports are reviewable. I want to turn to one last fact before I want to make a submission and then our closing remarks. The President's letter of last week contains 12 paragraphs. This is the letter to the court, and Justices Jafta and Fruneman, I would remind the court that the interest of justice test for direct access would include a statement from the President of the court, from the President of the country, where he says in paragraph 3, although procedural questions have been raised on behalf of the President, including this court's exclusive jurisdiction and direct access, the President says, matters which are ultimately forth, the need for finality is apparent. So in these unusual circumstances, the President has told the court that the need for finality is apparent, and it would fit into the kinds of ideas that this court spoke to in independent newspapers. But I do wish to emphasize paragraph 6, because it's not unimportant in our submission as a fact. In paragraph 6, the President says, he has proposed that the Auditor General and Minister of Finance designate an appropriate person each to carry out the exercise, the substitution for SAPS of the AG, an independent Chapter 9 institution with a mandate to strengthen constitutional democracy, can only enhance the process, etc. And that was obviously bearing in mind the changed circumstances arising from the controversy regarding the SAPS report. It wasn't a SAPS report, and this is important. It was a Minister of Police's report. The President confuses the distinction between the political office bearer of the Minister of Police and SAPS. The Public Protector required SAPS, who are not political bodies, there's a Commissioner of Police, to deal with the issue. And then the next, and there's a footnote 3, which deals with the President's answering affidavit in the DA application, in particular paragraph 54. And then the important sentence that we ask the court to consider in the most serious light. The EFF, DA and Public Protector have not responded to this proposal. The DA had responded to the proposal. And that the court will find on page 1213, the DA's reply of Mr. James Swelf of 20 November 2015, where in paragraph 43, he qualifies what he said in 42, and he deals with that in terms, proposal by the President contained, as the reference indicates in the letter to the court, in paragraph 54 of the President's answering affidavit in the DA application. So when the President told the court that the DA had not responded, they, as a fact, have responded. The last point I wish to take from this letter is, as short time as a week ago in paragraph 10, the President tells the court that he's considered the proposal seriously and upon legal advice, etc., believes its acceptance will end a drawn-out controversy and promote nation building and unity. I don't want to get involved in the President's duties on nation building and unity, but I do want to emphasize this. The President approaches the matter on the basis of the issue of the exact nature of the public protector's remit is pending in a few weeks' time. That's, of course, no longer true. The President couldn't have known that. I understand that on the 3rd of February, the Chief Justice issued directions where that matter, which was scheduled to be heard on the 10th of March this year, has now been withdrawn. That was on the 3rd of February. That's last week. So it's the day after this letter. But then he says, and a practical arrangement between the parties endorsed by the court to implement, and what does he say a week ago? The recommendations in this instance. So as short a time as a week ago, the President maintains the stance in the letter to this court that the public protector's remedial action is a recommendation. And we would emphasize this in the big basket of facts, which starts with obstruction and ends with a week ago, to a letter to this court where he continues to suggest that they are mere recommendations. I do want, before I turn to the final conclusions, Chief Justice and Deputy Chief Justice, to make two, let's call it self-standing points in how this we would submit, the DA submits, this court should consider the matter, and then I'll turn to the relief sought. The facts of what the President did and didn't do, and what the National Assembly did and didn't do, and Minister Police did or didn't do, are common cause, effectively. It's another factor, Justice Jafta, Justice Fruneman, as to why direct access is appropriate. There are no disputes of fact that a court needs to consider. And a fact is the graph that I referred to earlier in the Public Protector's report, which we would suggest. And we say this, not every submission that we make is serious, but there's an extraordinary seriousness about what we're now going to say in two respects. There's been an abuse of public resources at an extraordinary scale for the benefit of one family in a country where most families barely can afford food, education, healthcare, and housing. And that is it's a breakdown of the rule of law on a certain level. And we want to say the cost of the breakdown of the rule of law, and we want to emphasize this, and how it impacts upon the realization of human rights and poverty alleviation is clearly demonstrated, particularly in this case. But we don't just say in this case that the 250 million rand could have been used for education or otherwise. It goes deeper than that. I'll come to why. Because obviously, common sense tells you that if one family benefits 250 million rand at the public purse, when there are, let's say, 100,000 people who would be able to eat for a year on that money, that's obviously a violation of some type of. But it goes deep, and I want to refer in this regard to what Ms. Pillay, Nabi Pillay, said when she was the UN Human Rights Commissioner, the United Nations High Commissioner for Human Rights. She said this in 2012. And she said the rule of law constitutes the backbone for the legal protection of human rights. So when one talks of the rule of law rather than, in this kind of case, the rule of man, and really is the difference. There's a rule of law and a rule of man. In this case, demonstrates why the rule of law is so important. But what she said was this: the rule of law constitutes the backbone for the legal protection of human rights. And what we want to submit is that it's not just lofty language in the Constitution about the supremacy of the rule of law in Section 1. It's got a real meaning for human beings on the ground, poor people who deserve their dignity to be respected, protected, promoted under Section 7.2. And that's what this case is about. It's a 7.2 case at its heart. So we read that to you, and we can give you the reference. Ms. Blizzard will give it to you. We found it in a book called New Rules for the Rule of Law in David Marshall, the International Rule of Law Movement. And if the court wishes proofs of the book, we will say it with the registrar. If the court can request them, Ms. Blizzard will make it available. But we want to turn to the relief sought. And in our notice...
I'm generously giving you 2 minutes, and then I'll stop you.
Thank you, Chief Justice. The prayer in paragraph 1.1 sorts under 172(1)(a). And we don't believe, or we would submit, that it would be difficult to argue that, bearing in mind the clear language of the section, number one, this court's consistent jurisprudence, that where there has been a consideration of conduct in a constitutional setting and the failure, or the conduct constitutes a failure to comply with what the section talks to, which in this case would be the law, and the law being the public protector's remedial action, the court is enjoined to issue the declaratory. We make that point in our heads of argument. Similar considerations apply to paragraphs 2 and 3 in respect of the Speaker, the National Assembly in paragraph 2, and the Minister of Police in respect of paragraph 3. 1.2 is different. It's a different type of prayer. It's a structural interdict of a kind. And we accept that perhaps in our formulation, it may well have been better to have included in paragraph 1.2 a prayer that looks like 1.3.5. In other words, here we've asked the court to order the President to report back to this court by affidavit how he has complied with the remedial action. And what I suppose would be just and equitable, what we submit would be just and equitable, would be for at least the public protector, if not both the EFF and the DA, to be entitled in some way to respond to the President's report back, bearing in mind in particular the water that has passed under the bridge subsequent to the formulation of 1.2 by the DA before the 8th of October. And turning to costs, Chief Justice, we would submit that there would be no reason why, were, for example, only 1.1 to be granted, the DA shouldn't be entitled to its costs, including the costs of at least 3 counsel. We have 4. We understand that the costs of 3 counsel is unusual, and costs of 4 counsel is probably relatively rare. Couldn't find one. But here, the President has chosen 5 counsel, including 2 senior silks. And this is a matter of high constitutional importance, and there's much paper and very difficult and important issues, and we would ask that the court consider, under its just and equitable discretion, to go the rare route and give the DA a cost order to, indemnify all the cost that it's expended in this case, as it pleases the court.
Thank you, Mr. Kurtz. The court will adjourn for 15 minutes.
All right, well, live from the Constitutional Court there, those visuals where the economic freedom fighters and the Democratic Alliance case is being heard. Will Trengrove and Dalian Porfu are representing the EFF, so points being heard from them essentially revolving around the powers of the public protector and the upholding of the Constitution. For the DA, Advocate Anton Katz defining the legal position of the public protector's powers. And then also on the sidelines of this court case, the EFF being led by Julius Malema are set to arrive at the court for their Pay Back the Money march, but we will have some further analysis and some discussion on these things that are currently underway from the Constitutional Court, as well as that march that's coming back up next after the break.
be admin action, surely.
At the very least.
Yeah. You know, the point I want to make about that is very simply this. Hello, Karen.
I'm sorry. Excuse us. Sorry.
registered or printed.
Yes, Mr. Marcos, you have 30 minutes.
Thank you, Chief Justice. I propose to address 3 topics, and unlike my learned friend, Mr. Katz, I would like to invoke my 10 minutes of immunity. The 3 topics I propose to address are these. First, we will address our primary argument that the Public Protector's remedial action in terms of Section 182(1)(c) of the Constitution is binding and enforceable unless and until set aside by a court of law. And on that score, we will support the SCA judgment in the SABC matter. The second topic we will address are 2 counter-arguments to our principal argument. The first is raised by the Speaker to the effect that the sole source of the Public Protector's powers is the Public Protector Act and not the Constitution, and those powers on that argument are purely advisory. And the second counter-argument we propose to address is one hinted at by the President, and that is that the principles of cooperative government means that the Public Protector's remedial action may not be finally and legally binding, as they put it, without more, and we will submit that both arguments are wrong in law. And the final topic we will address is our contention, and it flows from our primary argument, that the President's response to the Public Protector's remedial action rested on an error of law, inasmuch as it amounted to invoking an impermissible parallel process designed to second-guess her findings. If I could then turn to the first topic, and it's the core argument I want to present, we can encapsulate our argument in 4 propositions which are based upon the lodestars of interpretation: text, context, and purpose. The first proposition rests upon the ordinary meaning of the words in Section 182(1)(c) to take appropriate remedial action. We submit that, ordinarily interpreted, this means that the Public Protector is vested with the power to cure or correct or put right the improper conduct which she has investigated. That is what an appropriate remedy seeks to do, and it is in consequence of an investigation and an adjudication which she is empowered to undertake. The second of the 4 propositions goes to the context in which that power is located within Section 183, 81 and following of the Constitution. Section 181(3) envisages that Chapter 9 institutions must be effective. That is why other organs of state are required to, and these are the words, assist and protect the institution of the Public Protector to ensure its effectiveness. We submit that to hold that the Public Protector's remedial action is not binding and enforceable would render the institution toothless. That is the very antithesis of the effectiveness which is required by Section 181(3). The third proposition is one partly dealt with by my learned friend Mr. Trengove, and it turns on the legislative history. The powers of the Public Protector in Section 182 of the final Constitution are significantly different from those contained in Section 112(1)(b) of the interim Constitution, which said that the Public Protector had the competence to endeavour to resolve disputes by various means, such as mediation, conciliation, negotiation, and advice. We submit that on general principles of interpretation, the change in language must be understood as a change in intention. There are many authorities to that effect. Could I perhaps just give you a relatively recent one? In Westinghouse Brake, it's 1986, Volume 2 of the South African Law Reports, page 555, Appellate Division as it then was, at pages 561 to 562. The last of our 4 propositions is this. In terms of Section 181(1) of the Constitution, the Public Protector is one of the state institutions that, and I use the words of the Constitution, strengthen constitutional democracy in the Republic. That identified object or purpose, which is served by the Office of the Public Protector, would be stultified if her findings were not binding and enforceable. To embrace the wording that this Court and the Supreme Court of Appeal has adopted, it would mean that there would be no protective framework at all for civil society, as it was put in the second certification case at paragraph 25, or there would be no defence against bureaucratic oppression, corruption or malfeasance that is capable of insidiously destroying the nation, as it was put by the SCA in the Mail and Guardian case in paragraph 6 and repeated more recently in the SABC judgment at paragraph 29. Those then are our 4 propositions. I wish to address one question which arose in the course of argument, and it was raised by Justice Kampepe. The proposition was that there is no equivalent in relation to the Public Protector of Section 165(5). That is, of course, correct, but what we submit is that the wording which does appear in Section 182(1)(c), namely to take appropriate remedial action, is merely a different formula with precisely the same effect. In this respect, the decisions of the Public Protector are not dissimilar from scores of statutory bodies like ICASA, the Financial Services Board, and many others, whose decisions stand and must be obeyed unless and until set aside by a court of law. Those statutes, seldom if ever, to the best of my knowledge, contain the equivalent of Section 165(5) of the Constitution, yet they have legal effect on the reasoning of this court in Kirland, and for very, very good reason. If I could then turn to the first counter-argument, and it is this. The Speaker argues that the Public Protector Act alone is the source of the Public Protector's powers, and there are no powers sourced directly from the Constitution, and the conclusion which the Speaker reached is, and I use her words, the powers set out in Section 182(1)(c) are to be construed through the prism of the Public Protector Act. In advancing that argument, our learned friends do not address the judgment of the SCA in the SABC matter, in which that very argument was advanced and rejected. We submit that that argument is unsustainable for 4 reasons. First, it fails to have regard to Section 182, subsection 2 of the Constitution, which makes it clear that the Public Protector has the additional powers and functions prescribed by national legislation. In other words, the Public Protector has, firstly, the powers conferred by Section 182 itself, and secondly, she has the additional powers which may be prescribed by legislation. Secondly, that argument is supported by the very heading to Section 6 of the Public Protector Act itself, which refers to the, and I quote, additional powers of the Public Protector, and this court held in Mankai that to the extent that there is any ambiguity, and we don't submit that there is, regard may be had to section headings. That was in Mankai versus Anglo-Gold Ashanti, 2011, Volume 3 of the South African Law Reports, 237, at paras 100 to 101. The third reason why we submit that argument is unsustainable is that one cannot ever interpret the Constitution through the prism of domestic legislation, because that inverts the principle of constitutional supremacy. As the SCA put it in the SABC judgment at paragraph 43, this argument would have the effect of the tail wagging the dog. And the last reason why the argument of the Speaker in our respectful submission is unsustainable is that the Public Protector Act predated the coming into operation of the final Constitution. The Public Protector Act came into force on the 25th of November 1994. The interim Constitution did not confer the power on the Public Protector to take appropriate remedial action. The Act could thus never have limited the purpose of giving effect to the Public Protector's powers, which were granted to the Public Protector later by the final Constitution.
Well,
so we would
now that the time has come to interrupt, you want to round up that point, and I have a question for you.
Yes, perhaps I have finished that point, Chief Justice. I was going to deal with the second counter-argument on cooperative governance.
Section 182(1). The Public Protector has the power, as regulated by national legislation, and then the powers are outlined.
Yes.
What is the meaning of as regulated by national legislation? Because I suspect that might well have influenced the Speaker's argument.
Well,
and two, as you deal with it, can the provisions of the Public Protector Act that appear to regulate, if there are any, I'm not suggesting there are any, that appear to regulate, be ignored just because the Constitution came into being after the Public Protector Act?
Yes, thank you, Chief Justice. Well, on general principles of interpretation, and I don't have the authorities with me, but I can find them, the power to regulate never includes the power to prohibit. So the mere use of the word regulate could never have the effect on general principles of interpretation of taking something away. So in the context in which it is used, it must have, in our respectful submission, a different meaning and a different connotation. And what we would simply submit in that regard is that it permits the national legislature to grant, as it were, additional powers which deal with the powers and functions of the Public Protector. In other words, I'm using the word deal with as an appropriate synonym for regulate.
In other words, where it might not appear to be clear, to provide some guidance as to how you are supposed to exercise the particular power.
That is correct.
Yes, yes.
That is correct. But the one thing, and I suppose this is at the heart of our argument, is it can never detract from the power actually conferred by Section 182(1)(c).
Supremacy of the Constitution.
Exactly.
And what about the coming into operation of the Constitution after the Public Protector Act? What do you want to make of that?
The only point we make of that is that the power to take appropriate remedial action was conferred by the Constitution because that was the later enactment. And therefore it's simply an argument which reinforces our interpretation.
Understand. If, and that's a big if,
yes,
there was something in the Public Protectors Act,
yes,
that seemed to regulate in the manner we have just been talking about any of the powers, including the power to take remedial action, what objection could we simply have based purely on the year on which the other came into operation?
Chief Justice, I don't for one moment suggest that that would be decisive of the interpretation. I merely submit that there are a range of factors which point to the proposition that the Constitution, 182(1)(c), confers an original power on the Public Protector. If I could then turn to the second counter-argument, and it is one which is really only hinted at, it appears in the President's heads of argument in the DA matter, I'll merely give the reference. It's at page 28, paragraph 40 of the President's heads. And what the President says in that paragraph, and I quote, "The principles of cooperative government which bind the PP in her engagement with other spheres of government, including the President, suggest that the PP's decisions may not be finally and legally binding without more." What we would submit in that regard is that it is simply wrong in law, primarily based upon this court's judgment in Independent Electoral Commission versus Langeberg Municipality. It's 2001, volume 3 of the South African Law Reports, page 925, particularly at paragraphs 27 to 31. And the short point is very simply this, that Section 41 doesn't apply to the public protector at all, because the public protector is not an organ of state within any sphere of government. On the contrary, the public protector, like the IEC, which is also a Chapter 9, independent of government. But the matter is, in our submission, put beyond doubt by the Intergovernmental Relations Framework Act 13 of 2005, which was enacted pursuant to Section 41 of the Constitution. Section 2, subsection 2E of that Act makes it clear that the Act does not apply to any of the Chapter 9 institutions. And for the sake of completeness, Chief Justice, this argument was disposed of by the SCA and the SABC judgment at paragraphs 24 to 25.
Well, as I understand the position, and correct me if I'm mistaken, there seems to be two somewhat different positions taken by the President in relation to the status or effect of the remedial action taken by the Public Protector. I got a sense that the latest position is very much in line with what the other parties understand the position to be. I may be mistaken. So on which of these positions have you chosen to hinge your argument, or which of the two positions have you chosen to target?
Of the President, I would obviously welcome a clear and unequivocal statement from the President that he or his legal advisors accepts the position as enunciated in the SABC judgment. If that is the position they adopt, then we have no difference with them. I struggle to find a clear position on that.
The position taken by Mr. Trengrove, his own understanding of what the President's position is, do you align yourself with it or not?
Yes, I do. I'm not going to contradict that argument.
Mr. Marcus, I'm sorry.
Pardon, Justice.
May I take you back to the earlier question put to you by the Chief Justice on the meaning of legislation regulating the powers of the Public Protector in Section 182?
Yes.
Is your submission that there is a distinction between that phrase, national legislation regulating the powers of the Public Protector, and the phrase that we normally find in the Constitution, where it contemplates legislation or national legislation giving effect to the rights? And if there is a distinction, what would you submit is the distinction? And could regulate be a subset of giving effect to, or the other way around? Are they completely distinct?
Justice Jondo, with respect, you make an important point. There are examples, and sections 32 and 33 are good examples, where the Constitution actually requires legislation to be enacted to give effect to, in those cases, the right of administrative justice and access to information. The wording that we find in the relevant section concerning the additional legislation concerning the Public Protector is actually different. It doesn't impose an obligation to enact legislation. It permits the enactment of legislation. It says the Public Protector has the additional powers and functions prescribed by national legislation. It doesn't, in fact, say the national legislature must enact legislation. Slightly different. The second is that we would, with respect, submit that the key to the interpretive debate, to the extent that there is an interpretive debate, rests not so much on words such as regulate or anything of that sort. It rests on the word additional. Because what that is telling us, in, we would submit, unambiguous terms, is that the section contains original constitutional powers, but that it is permissible for additional powers to be conferred by national legislation. When the national legislation confers those powers, they would be additional to those already granted, and I have suggested as a synonym for regulate the words deal with. I don't think that there is any suggestion, nor could there be, on general principles of constitutional interpretation, that one would interpret that legislation as permitting a cutback on the powers conferred by the Constitution itself. And let me say this, if I may, Justice Ondo, to the extent that there might be a terminological debate around regulate, of course one would always interpret the provision in a way akin to Section 39.2. I appreciate we're not dealing with the Bill of Rights, but this Court has recognised in other judgments that the same principles of reading legislation consistently with the Constitution has to be adopted. I think Van Rooyen is a good example where the powers concerning the Magistrates' Commission were held to have to be interpreted consistently with judicial independence. So it's not a principle which is confined to the Bill of Rights. Chief Justice, if I may then turn to my final topic, and a fair amount of the ground has been covered by my learned friend and I won't repeat it. I deliberately phrased it when I indicated what I was going to address as the President's error of law. And what I want to suggest is, in the light of some of the debate that has taken place, that whether or not it was in good faith is a red herring. And I say that because this Court has in fact, to a certain extent, addressed the relevance, perhaps more importantly, the irrelevance of good faith in the pharmaceutical manufacturer's judgment, 2000 volume 2 of the South African Law Reports, page 674, and at paragraph 13 of that judgment, the Court very simply said that the fact that the President was bona fide was irrelevant. And I don't wish to be misunderstood in any way. It is no part of our argument that the President acted in bad faith. That is irrelevant. We can assume, as we do assume, that he acted in good faith. The real question is, did he err in law? And if it was a material error of law, then that, on our argument, is with respect the end of the matter. And we do submit that he erred in law, and we advance the argument on an acceptance that he did so in good faith. Can I briefly just highlight aspects of the genesis of that argument? My learned friend Mr. Trengove has done so partly already. In his report to Parliament on the 2nd of April 2014, which you will find in the DA papers as JS5 at page 366, the President makes 2 points. He says the ministers in the security cluster were instructed to launch a full investigation, and on page 368, paragraph 2, he says, both the investigation by the security cluster ministers and the public protector inquired into substantially the same subject matter. So from the get-go, we have the beginnings of what we call a parallel process. Then on the 14th of August, the President sent a report to the Speaker. You will find that as Annexure JS8 in the DA papers at volume 4, page 502. And in that report, after summarizing the various reports he had now received a number of reports, including the report of the Public Protector, he states that he deems it appropriate for the Minister of Police to, and these are his words, and Justice Nkandla has highlighted this is a critical paragraph, it's paragraph 63.2 on page 520. He deems it appropriate for the Minister of Police to report to Cabinet on a determination as to whether the President is liable for any contribution in respect of the security upgrades having regard to the legislation, past practice, culture and findings contained in the respective reports. Now that clearly contradicts the Public Protector's remedial action, as the Public Protector makes clear in her response to that report. That response is important from our perspective. It is Annexure JS9, and it is found on page 524 of the papers. And I would, with respect, ask the Court to pay particular attention to what the Public Protector says. The important paragraph of the Public Protector's response is on page 528, and it's paragraph 14. And the Public Protector hones in on that very paragraph that I've just read, the one that Justice Nkandla drew attention to. She says this: paragraph 63.2 of your report states that you deem it appropriate, and she underlines deem it appropriate, that the Minister of Police reports to the Cabinet on a determination, quotation marks, of whether you are liable for any contribution in respect of the security upgrades having regard to the relevant legislation, past practices, culture, and the findings contained in the respective reports, including mine. I am respectfully finding it difficult to understand why this is deemed appropriate as. And then she sets out 6 subparagraphs, and I would draw attention to a few of them. 14.1, the only report making a finding that you and your immediate family improperly benefited from some of the measures implemented at your private residence by the Department of Public Works is my report issued on 19 March. The only remedial action taken in this regard is to be found in paragraph 11.1 of the report, and she quotes it. And if I could take you to the next page, 14.5, I am concerned that your decision gives an impression that you are unhappy with my finding, that you should pay, and point of view that the National Treasury and the South African Police Service should only assist you to quantify the reasonable amount to be paid. I'm further concerned, this is in 14.6, that the decision you have made regarding the Minister of Police gives him power he does not have under the law, which is to review my decision taken in pursuit of the powers of administrative scrutiny I am given under Section 182 of the Constitution and expected by relevant sections of the Executive Members' Ethics Act and the Public Protector Act. This, Mr. President, unintentionally requires him to usurp the review powers of the courts. And she then carries on. I could perhaps draw attention to paragraph 16 on page 530, because this makes the point crisply. As I have already indicated, reports of the Public Protector are by law not subject to any review or second-guessing by a minister and or the Cabinet. The findings made and remedial action taken by the Public Protector can only be judicially reviewed and set aside by a court of law. So she couldn't be more clear in what her concerns were. She articulates them with accuracy and precision, and the President himself couldn't be more clear in his response. You will find that response in JS 10, which is on page 531 of the papers, and again I would merely draw attention to a few paragraphs, starting with paragraph 3 on page 531. I must respectfully disagree with your assertion that reports of the Public Protector, and he quotes the Public Protector, are by law not subject to any review or second-guessing by a minister and or Cabinet, and the findings made in remedial action taken by the Public Protector can only be judicially reviewed and set aside by a court of law. That encapsulates, in our respectful submission, the error of law which the President has made. It's not necessary for me to read further, but I would merely urge the Court to read the letter as a whole, which I know that the Court will. The Minister of Police duly produces his report. The findings of the report are in direct contradiction to that of the Public Protector. He concludes that the President is not liable to pay for any of the upgrades. You will find that in Annexure JS15 at pages 633 to 634. And it's confirmed in the Minister's affidavit, which you will find at page 860 in paragraph 35, in which he says, "In my findings, I dealt with the features which the Public Protector has found not to constitute security features and therefore classified by her as non-security upgrades." And the President acts on that advice, as he says in his own words in his answering affidavit at page 895 to 6 in paragraph 17.4. He says, "Having received the Minister of Police's determination that there were not upgrades which were unrelated to security, there was simply put nothing for me to refer to Treasury for determination."
What is that page, as I remind you that your time is up? What is that page?
That is at page 895 to 6, and it's paragraph 17.4. And Chief Justice, I would merely wish to conclude with to clear up one potential misunderstanding. And it might have relevance later, I don't know. Let me deal with it very briefly.
How much time do you need for that?
2 minutes. 2 minutes, Chief Justice. In paragraph 11.1.1 of the Public Protector's report, and leaving out unnecessary wording, she requires steps to be taken to determine the reasonable costs of measures that do not relate to security and which include, and then she mentions 5 features.
Could you please give us a page of the Public Protector's report?
Yes, it's paragraph 11.1 of her report. Using the DA papers, you will find it at page 269. The only point I want to make is this, is that there should be no confusion whatsoever that the Public Protector has specified 5 upgrades which she has found do not constitute security upgrades, but that list is not exhaustive. And the use of the word includes is deliberate, and I can give you a shorthand. My learned friend Mr. Trengove has already given you the Public Protector's report at paragraph 10.3.2, but to make it easier, can I refer to the founding affidavit in the DA matter at page 18, paragraph 33, where Mr. Self lists a number of items over and above the 5 specified items, and that is undisputed by the President in answer. His answer, which is an omnibus answer, is to be found at 954 to 955, paragraph 169. Chief Justice, those are my submissions.
Thank you, Mr. Marcus.
Thank you, Chief Justice.
Ms. Steindam, you have at most 20 minutes, and we've agreed that you be not interrupted for 5 minutes.
No, Chief Justice, with respect, you offered me 10 and I accepted.
Oh, I said 10. Very well. And all right. Thank you for the correction. And would you indicate which of the issues that have not been properly dealt with you would want to address, just to avoid repetition so far as possible?
Chief Justice, our core submission is that the remedial action of the Public Protector has legal effect unless set aside on judicial review, and organs of state and public officials may not ignore it. That has been addressed by everybody so far, and I must note that the President conceded that point at paragraphs 3 and 7 of the President's submissions in response to Corruption Watch.
Sorry, are you going to address it or not?
I'm going to simply pick up on one or two points that I believe are not repetition, but simply add to what my learned friends have said. If I may begin, Chief Justice, I wish to respond to...
So that is the only point you're going to make? Remember, I said you must indicate which points you're going to address.
Chief Justice, if there is time, I would like to address the proper interpretation of 11.1 of the Public Protector's report. Chief Justice, you asked my learned friend, Mr. Marcus, a question as to the proper interpretation of Section 182(1)(a) of the Constitution, and in particular the meaning of the words there to regulate. And I'd like to address that question with your leave. So the wording is, the Public Protector has the power, as regulated by national legislation, to, and then we have the three powers that she's given. Our submission is that the meaning of regulate is that the national legislation may do anything short of prohibiting that power. And if I may give you the authorities for that, it's actually in our heads of argument. There's a long line of authorities. Paragraph 19 of our heads of argument, and it's at footnote 12. There's a section in Lawrence Baxter's book, and he in turn cites R.V. Williams, and then the Phumelela Gaming and Leisure case, which is of the case of the SCA, a recent case. And if I may just read you from paragraph 1 of that case. The SCA says, there this court adopted the principle that a power conferred on the Cape Provincial Council to regulate horse racing and betting did not empower the council to prohibit betting in a partial but most substantial manner. We therefore submit, Chief Justice, that the power to regulate must stop short of depriving the Public Protector of the power she is clearly given to investigate, report, and take appropriate action, but may create a menu of ways, of manners in which she may exercise that power. That could include the types of remedies that she is entitled to take. It may include the process of including giving the subject to investigation a hearing. The Parliament is free then to regulate in any amount of detail the manner of her powers, as long as it doesn't take that power away.
Steinberg, is it not clear?
It's not yet time, please.
I beg your pardon, Chief.
I don't mind shutting.
Don't mind. Please go ahead, colleague.
I beg your pardon, Chief Justice, Madam. Is it not clear from the wording of the Act itself in relation to reporting, Section 6, investigation, Section 7, findings in Section 8? The point that we make seems to be very clear from the provision that the regulatory effect of the statute does not itself take away the constitutional power in Section 182.
Yes, with respect, we would agree with that. The Act, however, reflects the wording of the equivalent provision in the interim constitution when it comes to remedial powers. Although although after the final constitution was enacted, other provisions of the Act were changed, that particular one wasn't. So it remains open to Parliament to regulate further if it so chooses, short of prohibiting the power to take remedial action. And I think it was Justice Zondo who made the point that the language in other sections of the Constitution is different. And I would submit that a good example is in fact in Chapter 9 itself. If you look at 192, which is the independent authority to regulate broadcasting, the wording there is 192 Broadcasting Authority, national legislation must establish an independent authority to regulate broadcasting. Now that wording differs from the public protector has the power. The public protector has the power irrespective of the legislation. In the case of the national broadcaster, the Broadcasting Authority, national legislation must establish that authority in the first place. It has no existence before the national legislation establishes it. The only other point, if I may, to pick up on in respect of this interpretation, proper interpretation of Section 182(1)(c), is that it's useful to compare the wording of 181(1)(2) to the wording of the remedial powers of other Chapter 9 institutions. I think most useful is the Human Rights Commission, which is at Section 184 2B. And there we see that the Human Rights Commission at 184.2 can investigate and report and can take steps to secure appropriate redress. Now, the take steps to secure appropriate redress is similar to the language of the interim constitution when it came to the public protector, but it stands in sharp contrast to 182(1)(c), which says to take appropriate remedial action. That, we submit, must be given a different meaning as to take steps to secure appropriate redress. With the Human Rights Commission, suggests that the Human Rights Commission may take steps to get another body to take the remedial action the Human Rights Committee deems fit. In the case of the public protector, it's a direct power to take remedial action herself. And therefore, at a contextual level, we would submit that there is another indication of her powers to take remedial action that has binding effect. The question was raised earlier as to the status of other reports that are generated in response to the report of the public protector. And I merely wish to refer the court to the judgment of the SCA in the SABC matter at paragraph 47, which dealt with a similar issue where the SABC had asked a firm of attorneys to create its own report in parallel to the public protector's report. And there, His Lordship Justice Nafsa said they can commission as many reports as they like, but there's only one that has legal effect on the SABC. And that's the Public Protector's report. And the reason for that is that she's impartial and she's constitutionally mandated. And with respect, we would submit that the same is true with the Minister's report and Parliament's report. They're entitled to initiate and write reports as they may see fit, but they simply do not have the status of the Public Protector's report.
There is, unless, of course, after their own investigation, they arrive at the conclusion that some of the findings made by the Public Protector are questionable, and on the basis of that approach a court of law.
Indeed, and if a court of law sets aside on review, that is the only way in which the Public Protector's report could not be implemented. And then finally, Chief Justice, in the President's submissions in response to Corruption Watch's submissions, the President concedes that the Public Protector's findings have legal effect until set aside. The heads argue, however, that in this instance, the Public Protector never intended to make a finding that has legal effect, but rather asked the President, or recommended to the President, along with other parties, that he be the one to determine the remedy. And very briefly, the argument turns very much the wording of paragraph 11 of the Public Protector's report. I'm at the extracts that the EFF annexed, which is at page 130 of the record. At paragraph 11.1, the President is to 11.1.1, take steps with the assistance of the National Treasury and the SAPS to determine the reasonable cost of the measures. Now, the Council for the President make much of this phrase, take steps. In fact, they hark it back to the wording in the Constitution of the powers of the Human Rights Commission, which is to take steps to ensure remedial action is taken. And they use that comparison to say, oh yes, really what the Public Protector means here is that the President, together with the National Treasury and SAPS, must himself make the determination in the first place. And we submit with respect that, firstly, on its plain meaning, that's not what it says. It says, take steps to determine the reasonable cost, not take steps to determine whether there are reasonable costs in the first place, whether there are items in the first place that need to be costed. But in any event, take steps.
Well, there are those steps include, I beg your pardon, identifying other items.
Correct.
Yeah.
But not taking
over and above those that have already been itemized by the Public Protector.
Correct.
Yeah.
And the second reason that interpretation is simply not viable is that the remaining sub-paragraphs 2, 3, and 4 are not prefaced with take steps. So it doesn't say take steps to reprimand the ministers. It doesn't say take steps to pay a reasonable percentage. Those are all direct orders. And then the only way to make sense of 11.1.1, the only way you can pay the reasonable percentage is if they've been quantified. And that's all that it means, quantify them, and then do the following three. And unless there are other questions, those are our submissions.
Thank you very much, Ms. Steinberg. Thank you. You are the only generous one. You've given us 5 minutes more. Thank you. We're going to take, Mr. Gauntlet and Ms. Nkosi Thomas, we're going to take a 30 minutes lunch break. And in case of doubt, just look at that watch or that other one. 30 minutes, and then we'll be back. The court adjourns.
Well, live there from the Constitutional Court, where the Economic Freedom Fighters and the Democratic Alliance's case is being heard. Points being heard there essentially revolving around the powers of the public protector and the upholding of the Constitution. So earlier, before the lunch break, we heard from the DA's advocate Anton Katz defining the legal position of the public powers, of the public protector's powers. Rather than just a short while ago, for the public protector, we heard from Advocate Gilbert Marcus making submissions before the court.
Yeah, that's right. Advocate Carol Steinberg for Corruption Watch just ending her argument there as well. We'll give you all the details on those arguments when we come back after the break. Stay with us.